All right, so good morning. My name is Megan Blakely. I'm here from CREATE at University of Glasgow. I'm going to talk about tangification of intangible cultural heritage. And I put the bottom in italics because I do appreciate the organizers adding that for me. I didn't add it on my title, but it helps to clarify a little bit what's going on. So through self-reinforcing intellectual property systems and norms, I'm slightly concerned I've thrown myself under the plenary panel bus by adding a term here that is not in the current field language, but I'm hoping to make a case that it's something that we should think about as IP lawyers and architects. Generally, how I'm going to proceed, I'm going to talk a little bit about intangible cultural heritage, just ICH. It's not something I was really even familiar with before I started my research in this area. And despite the fact that it interacts very heavily with IP systems, it's not something that I've heard talked about a lot. There's one major international convention on that. 2003 came into force in 2006 with 30 signatories. And my research primarily focuses on Scotland, England, and Wales, because what I wanted to look at was developed countries, particularly that were in unions or previously in unions, and how culture works in those systems. Talk about tangification a bit, and then talk a little bit through some examples so it gets a slightly less abstract. So as these systems have developed through international legal instruments and through domestic legal instruments, we've really created a knowledge-producing and culture-producing lexicology, basically, around if you talk about the same things that is medicine and science in one country, let's say the Western IP system, then it's science, as opposed to traditional knowledge, the same sorts of things you're talking about. And my argument is that all cultures, all societies produce knowledge and produce culture. But what has happened through these instruments that we've created, we've widened this divide, and therefore the legal systems circularly reinforce the kind of cultural product that we're putting out. We're all familiar with the burn. And not until 1970 then did one of the first global international heritage conventions go through, and that focused very heavily on landmarks and built heritage, and hence leaned very heavily towards Western and European ideas of culture, columns, places you can visit. And so that was a bit of contention for other cultures that had things that were equally culture but were not included on the World Heritage List or were not available to be listed. So TRIPS went through, you get a little bit more of a heavy hand to enforce IP, and at that point there started to be a lot of discussion about intangible cultural heritage and how to protect that in the face of a rapidly expanding IP market. So then we come up with the 2003 convention, and they used the term safeguarding as opposed to protecting or owning, and it was a very intentional word choice because of the nature of ICH. So what is it? The main features, the important features, is that it's constantly recreated by a community that practices it and as a part of the identity of the practicing culture. So immediately, if you're a lawyer and you're trying to protect something, you need to define it and make it very precise what it is, the boundaries are that you're identifying for protection. And this type of behavior kind of defies that and makes it very difficult, because once you try to do that, it ossifies it, it stagnates it, it prevents it from growing, because only within those boundaries is it protected. I know it's a lot of text here, but I just wanted, in case anyone was interested in the whole clause. So as I said, mainly constantly recreated, mainly sense of identity, but they use some examples, non-exclusive, non-closed lists, oral traditions and expressions, performing arts, social practices, rituals, events, traditional craftsmanship. Many things are encompassed in this, and many of these things are getting swept up into IP protections that generally should be held by a practicing community. So if you do sign on to the convention, what are your actual obligations? That includes listing and indexing the ICH, promoting awareness, education, participating with the international community about what other countries are doing to protect their ICH, and then there are two lists. There's a representative listing and urgent safeguarding. So 162 parties in 2015. As I mentioned, you had 30 in 2006 when it came into effect, so that was a pretty large uptick. However, US, UK, and the Republic of Ireland are not among the current parties to the convention. So why are they not parties to the convention? just, those are sort of our outstanding countries anyway that try to retain sovereignty in the international community anyway. That aside, specifically dealing with that convention, it could just be another form of exclusionary listing. I got some great feedback at Ipsc on this, what is it that is a problem then with the listing? Are we just creating another system? So I've thought a little bit more about this. It is a problem when you talk about community participation, which it's big on, even representation within that community, power balances, and what is the actual value of doing this. But the main thing that sort of kickstarted this entire area of research for me was reading this quote from interviews with heritage practitioners in the UK. They kind of go back and forth about it's not really our approach, but in the end they say the UK has no intangible cultural heritage. And I just thought that was very surprising considering the source, and also very wrong, and it indicated sort of an institutional entrenchment of that culture-producing versus knowledge-producing society. Anything that's of value, then we want to make it intellectual property, and if it's not easily ownable, sellable intellectual property, then it's not of value. We don't have it. It's something that they have over there. It's related to IP, as I said, because we try to take all these things that we do have and put them into protectable IP buckets. So let's say somebody comes to you and says, well, I have these certain types of practices or ideas or expressions, or what can I do? And you as a lawyer might say, well, if you change this little bit about it, then it could be copyrightable, and you probably want to trademark on that, and then any part of it that might be, patent eligible, you might advise them to look into that a little bit. But you would almost always say, how do you protect this through an IP system? And I like this little, here, how do you know if it's even music? It might not be music, so then maybe it's not protected. You have subject matter, authorship, duration, and as I mentioned before, as there's more technological advancement, these types of ICH, cultural practice, ritual, tradition, they have a much wider reach now throughout the globe. Right, so back to the tangification. To step in the propertization chain, I added the few little bits of definition that I mentioned earlier that are important. So you start with ICH, and the important thing is that it's constantly recreated by communities and groups in response to environment, interaction with nature and history, sense of identity and continuity. You can have something be tangible, fixed, ossified, possessible, not necessarily owned already in IP, because of the eligibility issues with copyright. And then you get into propertization, then it can become a commodity, which means then you can sell it, and then it could be commodified and commodity. I still haven't changed these two, and I always reverse them, but basically it is a sellable item. And then if it becomes a commodity, then it can just become any sort of generic good that has no real personal identity or community attachment to it, and you lose everything up here in ICH that makes it what it is. So that is the step that I think with particularly ICH, it doesn't get really recognized in IP. As I said, you can have tangification without propertization. Maybe it's just too old, but then it becomes fixed. Maybe it's recorded and it belongs to the community. And I'll give some examples so that I'm not talking in circles here, but as I said, Scotland, Ireland, and Wales. This is just a little argument that we don't necessarily need laws for everything. We don't need to protect everything to continue to exist and thrive. So I'll start with Scotland. Just as a side note, they did perform a domestic listing in 2008 in accordance with the convention, so they've done everything they need to do to sign on. And if they had the rights and were not a devolved nation, they did say specifically during the independence referendum that they would sign on to the convention, which I thought was very unusual to have any sort of campaign even mention this 2003 convention. So my main question that I'm going to be examining with this example is, how does domestic regulation affect community-led organizations? What happened here is that regulation and listing of tartans used to be handled specifically by clans, and it was all community-led and organized. And a lot of the ICH around that sort of thing is important, not just about the tartan, but all of the things that create the group, that the group does because of listing the tartan. So all of the events, the Highland Games, social interaction, community identity, and the National Records Service, it became a government function now to register the tartans in 2009. It's very early on, and so the research is ongoing as to what the effect of that will be on the other activities of the plan. And with the tartan, it is interesting because it was sort of an invented tradition. It was not, it did not always exist in the way that it does now. But, and many of the Scottish people, I'd say all Scottish people, are very aware that it was reintroduced. Tartan was banned during the 1700s, and what you see here is actually 1856. Princesses Helena and Louise, I think, Queen Victoria and Prince Albert's children. And this was after the ban was lifted and it became popular again in England. But it was used as a method of social control to ban people from wearing tartan. And when they realized that it could be used as a way to reintegrate Scots into society with the Union, that's when the clans were assigned. And they reached out to the clan leaders and said, you know, what is your tartan? Please send it to us. We'd like to record it. And they said, well, just pick a good one for me. I mean, a lot of them didn't know. They did wear it, but it was based on regional dyes, based on fashion, based on military regiments, that sort of thing. 1929 is one of the first advertisements that is on file using a tartan to actually put it in a positive light for Scotland. And this is the very controversial Commonwealth Games tartan that went on last year that was designed. Not everybody was a fan of it, but every tartan has a story. And on that basis, for our research center, I've actually gone ahead and registered a tartan just to see what the process is. And we designed it for the center with all the different sort of traits of the center, the different types of research we do, and you fill out the whole form, and I just think it was a really good, interesting way. They're very helpful, it was very efficient, and now it's on the website. And I do think the IP, the ancillary IP rights that might go along with this are very interesting, although they make it very clear that they don't confer any additional IP rights by registration. In Wales, language and festivals as intangible cultural heritage as a way to institute legal change is very interesting. In the Law in Wales Acts in the mid-1500s made English the only official language of the courts there in public administration, and they weren't allowed to speak Welsh in court. So if you were represented, excuse me, represented in court and were called in, you weren't able to speak Welsh. And if that was your first language, that was very problematic in a power dynamic type of environment. So there is lots of very traditional, interesting ICH in Wales, including throat singing and annual festivals. And this is Eisteddfod, which is language and arts festival for Welsh. And this is in 1946 when it started to become popular again. It's very old, the first one's 1200s and that sort of thing, but obviously when the language was sort of taken out of public discourse, it really suffered. The speakers went down. But there was a movement to bring it back. There was the Welsh Language Society in the mid-60s. This is Eisteddfod now, which is very large and very popular. But I thought this was a great little piece here. So this, I missed the Welsh Language Act. So in 1967, they had passed equal validity, which basically overturned the ban in Welsh in courts. And in 1993, they had equal treatment, so now everything must be listed in both English and Welsh. And that's very recent. And it was largely precipitated by the Welsh Language Society. They did lots of activism regarding language, and they would put up signs in Welsh over all the English signs in the towns, and this really precipitated a lot of legal change. And my last example, Ireland, there's obviously tourism promotion, but when does it become cultural branding, and when does culture become intellectual property of a domestic government? And the Gathering is a great example of this. They have an entire pamphlet on what it means to be Irish. This postcard is something that was handed out in schools, and they asked all school children to write to their relatives overseas. Some people had very little opinion on this. Obviously here, some people had strong opinions on it, that it was a scam. They were after money of people who had been displaced from Ireland by the fighting, and